My name is Nicholas Rotz, and I'm happy to introduce Judge Amol Thapar from the Eastern District of Kentucky. Judge Thapar gained his undergraduate degree from Boston College, a law degree from University of California at Berkeley, and after graduating, he clerked for the Southern District of Ohio and the Sixth Circuit, and went on to work in private practice and as a U.S. attorney. And he was nominated and confirmed for his current position as a judge in the Eastern District of Kentucky in 2007 by George W. Bush. And I had the pleasure of meeting Thapar and taking a fantastic class with him here at University of Virginia 2 years ago. So happy to introduce you.
Good morning and welcome to a fascinating debate on immigration. I'm going to cut right to the chase so we can hear from our speakers. I want to introduce first Dr. John Eastman. He's a Henry Salvatori Professor of Law and Community Service at Chapman University School of Law. He's the founding director of the Center for Constitutional Jurisprudence, a public interest law firm affiliated with the Claremont Institute. His research interests include birthright citizenship, how to rein in a runaway judiciary, which is particularly interesting to me, and prosecutorial discretion and immigration. He clerked for Clarence Thomas on the United States Supreme Court and Judge Michael Ludig on the Fourth Circuit, and earned his JD from the University of Chicago Law School. As you'll see with both of these professors, there's a lot more included in your brochure about the conference, and you can read about them there, but we really want to get to their comments. Professor Soman is the professor of law at the George Mason University School of Law. His research interests include eminent domain and its limits, the benefits of smaller government, and whether Congress has the power to restrict immigration when looking at the original meaning of the Constitution. He clerked for Judge Jerry Smith, who you may have seen here on the Fifth Circuit, and he earned his JD from Yale Law School. We're going to have two topics today. I'm going to get right to the first topic. The first topic, which will begin with Professor Soman, is the legality and policy of immigration enforcement. Professor Soman will open by discussing the constitutionality of Congress's power to restrict immigration and go into policy reasons why he believes open borders are more consistent with free markets. He will have 9 minutes, followed by Professor Eastman for 9 minutes. They'll each have 3 minutes to rebut, and then we'll move on to the second topic, which surrounds United States versus Texas. So, Professor Soman.
I'd like to start by thanking the Federalist Society for organizing this event and all of you for coming. I'd like to thank the judge for moderating. And I would also say it's a particular honor to do this debate with John Eastman, who is one of the leading scholars in our field, and I've been learning a great deal from his work ever since I was a young assistant professor. Although, as you'll see, we disagree very significantly over this issue, we do in fact agree and have often worked together in the past on a wide range of other issues. Indeed, as you consider the issue that we're about to discuss today, I think there's no better way to consider it than in light of some of the principles that John has so eloquently defended in many of his other writings on other issues. Principles like free markets, limited government, colorblindness, and enforcing tight constitutional limits on the power of the federal government. These ultimately are the reasons why we should have free immigration. Let's take free markets first. There is no bigger government intervention in the economy than our immigration restrictions. They literally keep millions upon millions of people from taking jobs, renting homes, pursuing a wide range of opportunities that they could otherwise have. Economists estimate that if we had free migration throughout the world, we would actually double world GDP. That's not a gaffe, that's actually the real estimate. Doubling, let's say, think that's overly optimistic. Maybe it's twice as big as the real result would be. Still, increasing it by 50% is a greater effect than any other change in economic policy that we could possibly think of. And the reason why this happens is pretty simple. People become much more productive when they move from places where they have little or no opportunity to use their talents to places where they have much more. Just crossing from Mexico into the United States makes a person 3 or 4 times times more productive than they otherwise would be, even without improving their skills in any way. And the opportunities to improve their skills are, of course, greater in the US than where they initially came from. So there's an enormous amount of wealth that can be created for both immigrants and natives just by freeing up our immigration restrictions. But it would be a mistake to say that the issue here is primarily economic. It is also, and even more fundamentally, about freedom. When people come to the United States from poor and oppressive societies in the third world, they increase their freedom in many ways. Think of people fleeing religious or ethnic persecution, women fleeing patriarchal societies, people fleeing massacres such as what we see currently with ISIS, and many other similar examples. Also, of course, the conditions from which the ancestors of most of the people in this room fled from, in many cases during the era when we wisely did not have the kinds of immigration restrictions that we did today. If we had those back then, most of the people in this room, their ancestors would never have been allowed to come, and they would have had to languish in the oppressive places where they were before. So ultimately, this is about freedom, not just for immigrants, but also for native-born Americans as well. Because of immigration restrictions, millions of native-born Americans cannot hire workers that they want, associate with businesses that they want, benefit from the entrepreneurship of immigrants. Immigrants are, on average, more entrepreneurial than native-born citizens, and engage in all kinds of social and economic interactions. Moreover, the enforcement of immigration restrictions in many ways affects natives as well. For example, just last year, the Obama Department of Homeland Security said, we cannot enforce these immigration restrictions unless we engage in massive racial profiling. The one area where this administration says racial profiling is a good thing, and that racial profiling affects, of course, not just immigrants, but millions of native-born citizens whose sole crime is that they happen to be of the same race or ethnicity as people from some immigrant groups. If you believe in ending racial discrimination in public policy, this would be one place where we could start. There's actually no other area that I know of, at least, where federal law enforcement uses racial discrimination on anything like this large a scale, even under a liberal administration like the current one that is in general hostile to racial profiling. Therefore, this is a question both of increasing our economic wealth and opportunity, but also a question of freedom for both immigrants and natives. I think for many of us in this room, most conservative libertarians, one of the things we value is colorblindness in public policy. We don't believe that the government should discriminate on the basis of race or ethnicity. Why not? Because those are morally irrelevant characteristics. What race you are, what ethnicity, that says nothing about what kinds of rights you should have. It's not a morally relevant characteristic, and it's also not something that you have any control over. The same exact thing is true of the place that you happen to be born. In and of itself, being born on one side of a line on a map or another, that is a morally irrelevant characteristic. It says nothing about the kinds of rights or the amount of freedom that you should or should not have. Ultimately, we support colorblindness because we don't believe in restricting people's freedom based on their choice of parents. And the same thing is true when it comes to where you happen to be born. Doesn't mean we can never have any restrictions on people's movement of any kind. We can restrict the movement of terrorists, violent criminals, people with contagious diseases, and so forth. But the key point here is that we can and sometimes should restrict those kind of movements regardless of whether the person in question is a native-born citizen or not, and regardless of where they happen to be born. I'm not arguing there should never be restrictions of any kind, merely that those restrictions should not be based on who you chose for your parents and on what sign of a line in a map you happen to be born in. So I fully recognize, as with everything else, immigration does have downsides. Nothing is a free lunch. However, with virtually all of those downsides, either they are overblown or they can be addressed by means less draconian than forcibly consigning people to lives of poverty and oppression in the third world. Here I'll just mention one example, but similar points apply to other standard counter-arguments. For instance, many of you may be concerned that increasing immigration might lead to increased welfare spending. The social science research actually doesn't support this. Controlling it for other variables, states with more immigrants do not have higher per capita welfare spending than other states. In Western Europe, nations with more immigrants actually have lower per capita welfare spending than nations with fewer, because people tend to be more against welfare spending when they think that it might be spent on immigrant groups. But let's say you're still concerned about this problem, you'd like to drive it even lower. It's an obvious solution. Simply deny welfare benefits to this group of people. The 1996 Welfare Reform Act already does this for many welfare programs. You can try to extend that if necessary. If conservatives devoted their efforts to this rather than to immigration restrictions, that would be both more productive and effective, and it would be enormously beneficial for both immigrants and natives. And other complaints raised about immigration have similar solutions that for both immigrants and natives would be better than immigration restriction. We can talk about some of them, I'm sure, later in the debate. Finally, I'd like to talk a little bit about Congress's power to restrict immigration. And if you read Article 1 of the Constitution, you rapidly come to a very simple conclusion, and that is that power simply isn't there. It's not listed. There is listed a power over naturalization to grant or withhold citizenship. But of course, as both the Founding Fathers and we today recognize, naturalization is not the same thing as movement. People can be in a place without being citizens. And similarly, their movement sometimes can be restricted even if they are. Today, one might say, well, this power must come under the Foreign Commerce Clause, the power to regulate commerce with foreign nations. However, it's important to remember that at least as a matter of original meaning, simple movement from place to place was not considered commerce. The very same clause that gives the power to regulate foreign commerce also gives Congress the power to regulate interstate commerce. Nobody at the time of the founding or for decades thereafter thought that that gave Congress the ability to ban people from moving from one state to another. And of course, if the Interstate Commerce Clause, as an original matter, doesn't include that power, then the Foreign Commerce Clause, which is this very same clause actually, also cannot give it either. And John is actually one of those who has argued for a narrow interpretation of commerce power in other contexts. I think the same point applies here. For the first 100 years of American history, this was actually the dominant interpretation of the Constitution, that Congress did not have this sort of power. And it wasn't until the 1870s and 80s with the Chinese Exclusion Act that Congress enacted immigration restrictions systematically as a result of an upsurge of anti-Chinese racism. And in 1889, the Supreme Court did uphold the Chinese Exclusion Act. They said, we recognize this power isn't actually listed in Article 1 of the Constitution, but we're going to say that it exists anyway because it's inherent. It's something that all governments must have. Well, I would say two things to that. One is the federal government got along for 100 years without having this power, so it's not at all clear that they must have it. Second, if you want to say that inherent powers are just there without needing to be enumerated, then why do we enumerate things that are even more inherent, such as the power to declare war, raise armies, and so forth? That would seem to be even more inherent than any kind of power to restrict immigration, yet it had to be enumerated. The whole point of enumeration is to ensure that Congress's powers, the federal government's powers generally are limited, so the stuff that is not enumerated, that stuff is not included. That's the basic interpretation principle that originalists usually apply to questions of federalism, and they should apply it to this question as well. So ultimately, I will leave you with this. I think, at our best, we should be the nation of the Statue of Liberty, not the nation of walls and deportations. Freedom for both immigrants and natives alike, that is what will make America great again. Thank you.
Thanks very much, and thanks to the Federalist Society for having me here. I want to give a brief commercial advertisement. The Claremont Institute is the host of the Marshall Fellowships. Many of you know of these fellowships. Our window for applying is open right now, and we will teach you something about the natural law foundations of the American Constitution and Declaration in a lovely week in Newport Beach, California at a resort, and come this summer. But go to claremont.org and look at the application. Several several of you have already been involved in those fellowships, so I urge you to seek out your colleagues here and ask them what they thought of it. So Ilya has kind of taken on the mantle of Richard Epstein, get as many points out there as I possibly can in the time available to me. And I'm going to try and to respond to them. The first thing I want to note, though, is that most of his arguments are policy-driven. Free markets are going to lead to enhanced economic liberty. We should be colorblind. This is not just true on the basis of race, but also on the basis of where you're born. And then he concedes immigration does have its downsides. And then we talk about the social science data. The one thing I learned from some of my economics professors who studied with Milton Friedman is you don't have to look at all the data. That can be manipulated. Just ask how people react. And if immigration was such a positive, the states that are most likely to have large immigration would be fighting over to get more of it. And we find exactly the opposite. Arizona, Texas, Southern California have serious problems. And so one needs to ask, why is it that they support restrictions? But the real question here is not which side of that argument is it beneficial or not. Where in our constitutional system is the power to make those policy judgments assigned? And here's where I really want to engage in Ilya. He says, it's not a power given to Congress. And I think it is so clearly a power given to Congress that they didn't even need to specify it. It was so well understood. But I do think they did specify it. The notion that it's not contained within the power of naturalization, I think, is an anachronistic view of the power of naturalization. We look at it as merely the power to confer citizenship and not having anything to do with who can immigrate into this country in order to obtain citizenship. But of course, in 1787, when that clause was written, immigration and naturalization were largely synonymous because of a couple of facts that operated then that don't operate now. You didn't cross the Atlantic in a number of hours. It was a 3-month-long journey. You did it once in your life. If you were a diplomat, you had to do it several times, but you did it once in your life. Taking on that trip meant you were relocating and taking on a new allegiance and becoming a member of a new body politic. The second thing was property laws. If you were not a naturalized citizen, you could not inherit and many times could not even own property. And so before you made the decision to immigrate, you had to know what the naturalization rules were. And so giving Congress the power to naturalize, to determine who can become citizens, who will become a member of our body politic, necessarily encompassed the power to decide who could come here in order to put themselves up for that naturalization. And I think proof of this, that this was the understanding of the naturalization power, is the negative implication of Article 1, Section 9, which specifically says Congress shall have no power to limit the migration or immigration of such persons that the states are willing to admit until 1808. Well, what is the negative inference of that prohibition on Congress's power? That they do have the power to restrict migration and immigration, and that they cannot exercise it until 1808, but thereafter the power will be restored. Obviously, this thing was aimed at slavery, but it doesn't just say immigration. I mean, it doesn't just, it says migration and immigration. And that meant it applied more broadly. And the inherent power that I think the court adopts, the notion that this is essential to sovereignty, that the court adopts in the Chinese exclusion cases, I think is right. It didn't begin in the Chinese exclusion cases. It began 40 years earlier in the passenger cases. Now, this was a case where New York and Massachusetts had each imposed a head tax on every passenger arriving from overseas into their ports. The court holds in that passenger cases the power to grant ingress and egress to and from its territory belongs to every sovereign, and citing Vattel, among others, for that proposition. And I think that's right. Call it an inherent foreign affairs powers. It's one that the court has subsequently recognized in a lot of areas. But that inherent power distinguishes what between the states and the federal government. Madison says, for example, in Federalist 42, that we leave the things to the states that are of local concern, but we have assigned to the national government all of the things that are inherent in the definition or understanding of a national sovereignty. And the notion to control one's borders was such a critical aspect or a core aspect of sovereignty, it would have been bizarre for them not to have recognized this power in the national government. Now, the passenger cases, and the flip side of those cases, which is the states couldn't impose that tax because it was an intrusion on foreign commerce. Congress, therefore, could impose a tax because it was an exercise of the foreign commerce power. Not a tax, but to use the tax, the imposition, as a way to regulate or control immigration. The court upheld that. Now, you might say, well, that's fine, well and good under the foreign commerce power, but what about immigration that does not involve commerce? The court uses language in those two cases to say that the engaging in the trade of passengers, of bringing passengers is an article or an aspect of foreign commerce. This is Gibbons versus Ogden, which if it's not a part of commerce, we would have to overrule, I suppose. But what about those that are not coming on a ship? What about those that are not coming on a train or a caravan across a land border? What about those that are just walking here? There's nobody engaged in the commerce of transporting those passengers other than they themselves. Of course, we have to more narrowly interpret the word commerce, and I think the founders did to accept such a proposition that would not be included. I mean, I'm pretty strict on understanding the Commerce Clause, nearly as strict as anyone in the country. But the founders thought it meant not just the trade in a good, but the intercourse between the two nations. And obviously, people coming here to take up residence and engage in the economy would have been an intercourse between the two nations. So I think, so a combination of things, the naturalization power, the foreign commerce power, more particularly it's inherent in the very notion of sovereignty. And I think this goes to the crux of the dispute here. What does it mean to have a sovereignty? The Declaration of Independence gives us some guidance on that. It begins when in the course of human events it becomes necessary for one people to dissolve the bands that have connected them to another, right? And then we set out the propositions that legitimize our claim of right to renounce our former allegiance. The one people language in there recognizes that even though all of humanity has fundamental, inalienable human rights, in order to secure those rights, we come together in certain categories, classes of people, geographically defined most often, to decide how we are best going to institute the government to protect those inalienable rights. That requires some recognition of a people that is distinct from other peoples. They all have the same natural rights to create their government and to defend their inalienable rights as we have. But inherent in that understanding is that you have the right to protect your borders, to protect your people, to secure the blessings of liberty and posterity for your people, to the preference of others. Right? And so if we're going to accept that proposition at all, then we have to recognize that the policy determination on how great a welcome mat to give out has to be made somehow, unless you say that there ought to be no distinction between citizen and non-citizen, no ability to control the volume of people that come at any given time. And the founders clearly did not have that open borders mentality. We don't see the cases dealing with restrictions on immigrations for a century, because they needed population. I mean, the policy judgment at the time of the founding was we need as many people here as we possibly can to, quote, to people the Western lands. It was both necessary for the success of the civilization, but also for defense purposes. If we didn't shore up our Western lands and our other borders, we would not have survived this thing. So it's not a surprise that we don't see cases dealing with restrictions on immigration early on. That doesn't mean that they didn't recognize there was such a power. In fact, all of the founders recognize that when we get to the point of imposing restrictions on immigration, we have to focus on what's necessary to protect the people here, right? And that means we could make distinctions on which governments, which other parts of the country, world the immigrant population comes from. Because some would be habituated to unrepublican natures of government that could cause problems here if they brought those despotic tendencies and habits to the United States, or brought them in such large numbers that they overwhelmed our Republican institutions here. These were the kind of concerns that were expressed in the Federal Convention, briefly, in the early naturalization acts in Congress, for example. And it's given that I think we have to recognize the Congress, the federal government, had the power to make restrictions when, in their policy judgment, such restrictions were necessary. And that's why the court, a century later, when it first confronted these issues, came to the notion that this is inherent in sovereignty, and more, that those kind of policy judgments are subject to the political branches, not for a judicial interposition. And that's why we developed the doctrine that Congress has almost unfettered plenary authority to make those policy judgments. The kind of arguments that Ilya made, therefore, are more properly made to the Congress, not to the courts. If you think they've gotten the policy judgment wrong or the balance wrong, then it's an inherent political decision that the legislative branch is entitled to make. And so that's where I think the fight has to be. I don't think Congress has the mix right at the moment. They certainly, with all of the unnecessary impediments and red tape to get through the process, but it's them that has to make the decision on where to draw that line, unless we're not just to destroy the notion of boundaries, but the notion of sovereignty itself. And that seems so counter to the very principles of the Declaration of Independence that we ought not to brook it. Thanks so much.
So I'd like to thank John for his excellent presentation. He is, I think, right about one thing, and that is that there are two separate debates here. One is about policy and morality. The other is about the powers of Congress. I was given to understand that we were going to debate both of these things and not just one, but I recognize that they are to some extent separate. You can agree with me on the one and disagree on the other, and that's fine, but I'm going to suggest that actually I'm right about both of them. I'll focus first on the broader moral and policy issues. John appeals to the Declaration of Independence, and I'm glad that he did that, because one of the grievances against the King of England listed there is that he had impeded immigration to the New World, and moreover, Thomas Jefferson, the author of the Declaration of Independence, was actually one of those that thought Congress did not have this power to restrict migration, and he said in his writings that people have a natural right to migrate from place to place, including that was the right that actually had been exercised by his own ancestors and those of all the people who came to America. John, I think, reasonably raises the issue, what about people who are habituated to unrepublican governments? Might they not come and screw up our Republican institutions? Now, if this were really a great danger, we should have excluded pretty much all of the people that migrated to the United States throughout its history, including, by the way, those who migrated from England before independence, because at that time and for decades thereafter, England was a narrow oligarchy. Less than 1% of the population had any real political power. So what Thomas Jefferson and many of the founders understood is that a society that has freedom and is Republican is going to be appealing to many people, particularly those like myself and many of the founders themselves who came from unrepublican governments that were much worse, and therefore that is the better way to deal with that situation rather than by trying to keep them out. You can also to some extent deal with it by having restrictions on voting eligibility and citizenship eligibility and the like that we can talk about in more detail later. And that brings us to the question of public opinion today. I think public opinion is a poor guide to government policy. I've actually written a whole book called Democracy and Political Ignorance, which explains why that is the case. Public opinion is actually ignorant about many issues, including this one. However, if you do want to go by public opinion, it is striking that on average, states with more immigrants tend to be more pro-immigration in their public opinion. That's one of very strong finding of public opinion research. So if you want to to go in that direction. I think that's telling. Those who know and interact with immigrants on a daily basis, on average, tend to be less hostile to immigration. They're not all as friendly to it as I am, but they're less hostile to it than those who tend to be immigration restrictionists. Now, let's talk about Congress's powers. John puts forward a variety of arguments, particularly under the Commerce Clause. He says, well, there has to be a power to use the Commerce Clause to restrict the business of shipping immigrants, such as in the passenger cases. However, in the passenger cases, what that was a tax on the use of commerce and commercial interactions in shipping. It was not preventing people from movement per se. You can say we can raise the tax high enough and therefore block movement immigration, but that would actually be a pretextual use of the commerce power. In McCulloch versus Maryland, Chief Justice Marshall famously said, you can't use powers pretextually for objects not enumerated in the Constitution. If you could use the commerce power, both foreign and internal, to leverage and control our freedom in almost every conceivable respect. You could say you can't engage in interstate commerce unless you do what we want on all kinds of aspects of your life, maybe even unless, for example, you eat broccoli or buy the kind of health insurance that the government wants you to buy, to name a case where John and I were on the same side. This would be a similar pretextual use of that power, and it would not be permitted under the approach taken by most of founders, and indeed throughout the first 100 years of American history. John says, well, they thought that it was an inherent power at the time of the founding. Not so. People like James Madison, Thomas Jefferson, Albert Gallatin, many others said that it was not. When there was a debate over the Alien and Sedition Acts, those acts were quickly overturned and repealed because the dominant view ultimately was that the alien part and as well the sedition part was unconstitutional. John also raises the issue of the migration and immigration clause, as he puts it. If you actually look at the text, it is the migration and importation clause, not immigration. And that's an important distinction because when you look at this power, it is, as John said, actually about slavery. And James Madison, in a letter that he wrote, actually said, this is about slavery. The only reason why slavery wasn't mentioned was that we were embarrassed to use the term. And he said it should not be interpreted as a power to restrict the migration of free people. You might say, well, why is the word migration there in the first place? It's because the power to regulate foreign commerce probably did include a power to regulate the importation of indentured servants who were not slaves, but were brought over in a kind of explicit commercial transaction. That was an important form of migration in the 18th century, but rapidly became much less important. Finally, John says, well, naturalization and immigration were basically considered more or less the same thing. This simply isn't true. From the very first Naturalization Act in 1790, there was widespread recognition that there could be people coming and living here who were not citizens, and indeed both that act and subsequent acts included periods saying that you're not allowed to become a citizen even unless you've been here for a number of years. That number was increased over time, and it's true, state laws at that time, before the 14th Amendment, were allowed to discriminate against non-citizens with respect to property law, but that varied by state. Some states did this, other ones did not, so it was not a categorical bar to immigration. Finally, with respect to the question of inherent powers, as I said before, Congress got along without this power for close to a century. Clearly, it wasn't absolutely essential. It's true. You need to exercise a right of defense against people who might threaten our rights, but simple, peaceful migration is not a threat to our natural rights. You can have defense against foreign armies, terrorists, contagious diseases, other threats of this sort. It doesn't require a general congressional power over immigration, nor was it understood to require that at the original meaning. I'm not, too wild-eyed or radical. I'm not saying we can immediately overrule a precedent that's been on the books for 130 years. Sadly, we can't do that. But I think we should at least recognize that it was wrong and over time gradually move in the right direction. Thank you very much.
Quote Justice Frankfurter here. Really is asking us not to, quote, overturn merely a page of history, but a whole volume of history. And so let me kind of go piece by piece through this, because I think there are several things that are just not not so. The Jefferson inalienable right to emigrate, which is right. In fact, it's at the heart of the Declaration of Independence. You have a right to renounce any former allegiance. That's a dramatically different thing than claiming a right to demand of some other new country that you become a part of that body politic. The notion of consent of the governed requires that the people that you are seeking to immigrate into give their consent. So I have the right to renounce my former allegiance, but I don't have the right to take up in your house if you don't want me. I have the right to sell off my last property, but I don't have the right to demand that you give me access to yours. And so oftentimes treated as two sides of the same coin, those are radically different propositions. And Jefferson always took the first and never took the second position. All right. This is, by the way, what's wrong with our treaty with the Emperor of China that led to the Chinese exclusion cases and the Supreme Court's decision in Wong Kim Art. We refuse to allow Chinese immigrants to this country to renounce their former allegiance to the Emperor of China. And therefore, even though when we allowed them to immigrate, we would never let them renounce that allegiance and take up a new allegiance here. All right. Not because we didn't want to allow them to have it here, but we refused to let them to renounce their former allegiance. And so that part of the Declaration of Independence was violated there. But Jefferson never took the opposite position. Now, the other things we have here, it's not something that arose 100 years later. The founders, right at the beginning, the very first Congress dealt with this and made the tie explicit. Representative Lawrence, when they're talking about the very first naturalization bill, he says, he ties it directly to immigration. The reason of admitting foreigners to the rights of citizenship among us is the encouragement of immigration, as we have a large tract of country to people. And that's the reason why in the Declaration of Independence, the charge leveled against the king is that he is interfering with immigration to this country. Because the policy judgment that they had made is we needed immigration to people the Western lands and what have you. That doesn't say anything about the lack of power of the central government to control immigration. When we need larger immigration, they use the tools they have to encourage it. But when the larger immigration becomes a problem, they also recognize that that same power inherent in sovereignty allows us to restrict immigration. And this was the holding of the passenger cases and the subsequent cases, which were the flip side, the head money cases. The reason that New York and Massachusetts were not allowed to impose that tax on passengers was because it was a restriction on immigration, a power that was expressly and exclusively delegated to the national government, because it was a matter of national concern, not of local concern. So they didn't decide it on the question of a pretextual tax. They decided that they had no authority because it was a restriction on immigration. And when the flip side case came up and Congress imposed an identical tax on passengers, the court did not decide that case on whether it was a valid tax or what have you. They talk about the taxing power a little bit, but that's not the basis of the holding. The basis of the holding is the power to restrict immigration is a plenary power given to Congress on the power of foreign affairs. Now, Elia points out that it's part of the same clause as the interstate commerce clause. But there's a prohibition on interfering with interstate transportation of citizens in Article 4 that doesn't exist there's no such prohibition on interfering with the transportation of foreigners coming to the United States. And the reason for that is that would violate basic norms of sovereignty if you could not control your borders in a way that restrictions on the ability to impose restrictions on interstate travel among citizens would have been inappropriate. So the two are dramatically different. The fact that they're in the same clause in the Commerce Clause doesn't tell us anything about the nature of inherent sovereignty. There are other aspects of this early debate in 1790 on the first Naturalization Act that I think are important because they identify right from the beginning the need to have some restrictions. And I think maybe I'm wrong about this, but I think even Elia would recognize that some restrictions have always been in place. The prohibition on criminals coming to the United States, or on paupers, or on idiots, or on, this is their language, not mine. I'm not channeling Donald Trump here. Or on people with contagious diseases. All right, now where does the ability to prohibit somebody's entry into the United States because they're carrying a contagious disease, where is that enumerated in Article 1, Section 8? It's not. All right, but the notion that it's not that part of the power of the national sovereignty was so beyond their comprehension that they didn't need to enumerate it. And you go on, Representative Sedgwick in the 1790 debates talks about broader things. The citizens of America preferred this country because it is to be preferred. The like principles he wished might be held by every man who came from Europe to reside here. But there was at least some ground to fear the contrary. Their sensations, impregnated with prejudices of education, acquired under monarchical and aristocratical governments, may deprive them of that zest for pure republicanism which is necessary in order to taste its benefits with the gratitude which we feel on the occasion. So some kind of probation was absolutely requisite. All right, and that's a concern about immigration, not about naturalization, even though that discussion is occurring in the debate over the naturalization bill. And it's not an outlier. This was the general understanding at the time, that we could restrict immigration and citizenship. The two were, well, like I said earlier, went hand in hand, in order to protect the Republican habits and Republican institutions here. And that also means, as a matter of policy judgment, when you do open up immigration, you get to decide as a matter of policy how much immigration can be permitted consistent with the protection of those Republican institutions. If you overwhelm with massive migration of people who do not share those Republican habits, you could so fundamentally change the Republican nature of our institutions as to undermine the very claim of legitimacy of the government. And on that question, which is a balancing test, there's no question that a century and a half now of Supreme Court precedent, it says the plenary authority to make those policy judgments and determinations is vested in Congress, is the embodiment on this question of the inherent national sovereignty that every sovereign, as recognized by Vattel, every sovereign has as part of the core aspects of sovereignty. That's why I think we have to begin in assuming that Congress can make these judgments and then determine whether we think they've gotten the balance right. And you know, like I said earlier, I think maybe they haven't, but it cannot possibly be the right answer that there is no ability to control or make those judgments whatsoever any place in the national sovereignty. Thanks.
It's a lot easier to control time limits in court than it is in here, but I think what we'll do for the second topic is I'm going to make a judicial decision that we want to get to it because it's about whether prosecutorial discretion vests with the president the power to enforce or not enforce our immigration laws. But what I'm going to do is, so that you all can ask questions at the end, is give them each 7 minutes, and I will interrupt this time, I'm warning you. And then we won't have rebuttals, but they can fit it into answers to the questions, because I have a feeling that questions will come from the audience on this. However, if you want to reserve time for a rebuttal, Professor Eastman, you're welcome to.
I will reserve 1 minute. You're going after me anyway. You're good. All right. So,
1 minute, you said?
no, he's got 1 minute. I'm not going to reserve. I'll fit it in on questions. So we've got two issues on prosecutorial discretion on the president's executive actions on immigration. The first is there a line, and is it a judicially enforceable line, between case-by-case prosecutorial discretion and wholesale changing of the rules that amount to a categorical suspension of the law? And on that question, the Supreme Court has always said there is a line. It's never defined what that line is. But it does have a couple of wonderful things. In Heckler versus Cheney, for example, it recognizes there is a line, and that if we move from case-by-case discretion to categorical changing of the rules, then that can't be done without violating the president's constitutional obligation to take care that the laws be faithfully executed. And I think that's why the Supreme Court added to the questions presented in the cert petition and Judge Smith's brilliant decision in these cases, the take care clause on the faithfully executed. And this has been around, this notion that there is such a line has been around for a long time. 1838, a wonderful case called Kendall versus United States. The court holds, to contend that the obligation imposed on the president to see the laws faithfully executed implies a power to forbid their execution is a novel construction of the Constitution and entirely admissible. And let me just tease this out just a little bit. We all recognize in prosecutorial discretion, we're not going to enforce every violation of the law. How many, when you drive on the highway, occasionally go more than a mile or two over the speed limit? Right? And if you pass a highway patrol officer, do you lose any sleep if you're only a mile or two? You might even wave at them without worrying about it, right? All right? But that doesn't give you entitlement down the road to continue to speed. Right? And so one of the most interesting aspects of the president's claim of prosecutorial discretion here is not only have I determined not to prosecute, and I use that word loosely because it's really not a criminal matter at all, it's a civil proceeding, not to put somebody into deportation proceedings, not to prosecute, but I've given them, as a result, a lawful presence in the United States. That's like saying, I'm not going to prosecute mere marijuana possession, but I'm giving you an entitlement to continue to possess it. Those are radically different things. Not prosecuting and giving you a lawful entitlement to it are dramatically different things. So I think the president has crossed this prosecutorial discretion line on both fronts. It's a categorical suspension of the law because he changed the rule, and he's pretended to give a lawful status to the lawbreaker that is not accurate. But even if you accept that's still within the realm of prosecutorial discretion, or that figuring out where that line was, how much discretion crosses the line to categorical suspension or not, is a judicially unenforceable line and therefore non-justiciable. There's another aspect of this, which is anybody that's in this deferred action is entitled to receive work authorization and other benefits that flow from it that the statutes do not allow. That cannot possibly be the exercise of prosecutorial discretion. And the General Counsel of the Immigration Services back in the Clinton administration recognized this. In a wonderful legal opinion, he said there's a categorical difference between not deporting somebody, in prosecutorial discretion, and then giving them affirmative benefits, such as a change in status or otherwise. The notion that fits within prosecutorial discretion is a version of prosecutorial discretion that has never existed before. And the Office of Legal Counsel memo, trying to rationalize this program, recognizes that. And they go out of their way to try and pin on 5 words in a definitional statute and the zillions of words in the immigration laws some authority for the Attorney General to have unfettered discretion to give out work authorizations whenever it wants. The law says you're not allowed to be employed in the United States unless you are an authorized alien. An authorized alien is then defined as somebody who is lawfully and permanently resident in the United States or who fits within one of the specific exemptions under this chapter, and then the last 5 words, or by the Attorney General. And they've put into that last 5 words the unfettered discretion for the Attorney General to give out work authorizations whenever he wants or she wants. And the non-delegation doctrine we have is largely dead. But even in its moribund state, the court has always gone out of its way to say there at least has to be some intelligible principle. Now, granted, what they've done with intelligible principles is laughable. Go forth and regulate in the public interest is a valid public. But or by the Attorney General doesn't even have that kind of a pretext in language. It doesn't say the Attorney General can give these work authorizations out if he determines it's in the public interest. That's not even there. So this would be, if their interpretation is correct, a bald-faced delegation of the legislative power that Article 1, Section 1 says has to be employed by Congress and cannot be given away. So much more likely, given that non-delegation problem with their interpretation, that all that language is referring to is many of the other provisions of the immigration laws that meeting specific identified criteria that are hotly contested and fought over every time Congress tries to put one of these exemptions through, that give the Attorney General the ability to waive the ban on employment of unlawful immigrants if they are facilitating an investigation or drug trafficking or human trafficking or whatever. The notion that it is an unfettered discretion that allows the Attorney General to authorize work to give work authorization, and then the Social Security and Medicare benefits and the retroactive refunds of earned income tax credits on your tax returns and all of these other demands on the public fisc without congressional authorization, I think is a stretch from the notion of prosecutorial discretion of the likes we have never seen before. And I think that's the other reason the court added that take care clause claim or question presented to the United States versus Texas case. We will see. By the way, the last piece on this is not one of the cases that the unfortunate and sad demise of Justice Scalia is going to affect. Either it's going to be affirmed by 4-4 split vote affirming the lower court decision, or if one of the justices on the conservative side goes south on us, or north on us, I don't know on that. It would have gone out the other direction either way. So it should be interesting to see what the Supreme Court does with this one by June, but I can't imagine they can read prosecutorial discretion as broadly as to both be categorical suspension of the law, but beyond that, the actual conferral of benefits for which there is no valid statutory authorization. Thanks so much.
8 seconds are going to be crucial to this entire debate. So I think this is an interesting and important case. It raises a number of novel issues, including this issue of the take care clause. In my view, in an ideal world, this case could be resolved very simply by simply accepting the proposition that I made in the previous exchange, and it was believed by people like Madison and Jefferson, which is that simply Congress did not have the power to enact many of these laws in the first place. But I accept, especially for the sake of argument, that the court is not going to do this. Even so, I think all or most of this is legal based on prosecutorial discretion and other also some statutory considerations. Let's talk about discretion first. We live in a world in which there is vastly more federal law than any president could possibly hope to enforce. Scholars suggest that over 70% of Americans have violated federal criminal law at some point in their lives. Perhaps even more than that have violated criminal or civil law. So we live in a world where almost all of us are federal lawbreakers, and the executive essentially has to make a choice of which small fraction of the many federal criminals out there he's going to pursue. And this necessarily involves effectively exempting large categories of people from prosecution, whether civil or criminal. I know this may be shocking to many of you, but there is in fact large-scale marijuana use on many college campuses. This is a violation of federal criminal law, yet it pretty much is never prosecuted on campus. Why? Because federal officials made determination, policy-based, moral-based, and otherwise, that they don't want to do this, perhaps influenced by the fact that the last 3 presidents of the United States were probably among those who use marijuana in this way. This allows many more millions of people to get away with violations of federal law than actually Obama's immigration order would do. Now, it is true you could say, well, this is case-by-case discretion, and it's not systematic discretion. But if you think about this carefully, the distinction between these two is actually artificial and meaningless, unless case-by-case discretion is going to be based on purely arbitrary determinations, flipping a coin or something of that sort. You're going to have some general rules to guide your discretion. They will be rules based on things like how dangerous is the offender, how severe is their violation, how important is this to public interest, and so forth. And this, of course, is exactly the sorts of considerations the president's executive order is based on. It doesn't say all immigrants are immune from deportation. It says certain subcategories that he believes, I think plausibly, serve the public interest better, people with children in the United States and the like, some other categories as well. And you can say, well, the president can't do this systematically. His subordinates can take these considerations into account, quote unquote, case by case, but the president can't do it systematically. This runs into a principle that I think may be familiar to to many people here in the Federalist Society the idea of the unitary executive. The power of the executive is granted to the president, all of it, including especially such core executive powers as deciding how and when to enforce the law. And the only way the president can effectively exercise that power in a large bureaucratic state is by issuing general instructions to his subordinates, which fetter and limit their discretion. That's consistent with the text of the Constitution, and it's also consistent with political accountability. At least at election time, we can credit or blame the president for this, whereas we generally don't get to elect or re-elect low-level federal bureaucrats and prosecutors and people of that sort. Now, I think probably the best argument on the other side of this case is the idea, well, maybe this is true for non-enforcement of the law, but it's not true for so-called affirmative benefits. I think the most obvious one is employment eligibility, as John mentioned. However, I think this is, in fact, authorized by the statute, which specifically says that among those who can get work permits are anyone who is, quote, authorized to be employed by the Attorney General. As good textualists, one of the things we might notice is that there's no limitation in that phrase and say only those who are useful for specified purposes like investigations and the like. In his very thoughtful opinion, my former boss, Judge Smith, says, well, Congress would not hide an elephant in a mouse hole here. But to my mind, I don't see a mouse hole. The elephant is right there in front of us in the very text of the statute. When something is clear in the text of the statute, good textualists should give it its full meaning. They should not read into it policy-based exceptions that they might want to have. And I think that's clear. When the elephant is right there and not in some mouse hole, we have to say, yes, there is in fact an elephant there. And that if Congress wanted to have a more narrowly restricted power, they could easily have worded it this way. And indeed, we're talking about a statute that has many very precisely worded limitations and other things. Could have done so here, but they did not. Finally, on the issue of the take care clause, the Supreme Court has never really tried to interpret these words faithfully executed, which I think are the key words for this case. And I would be lying to you if I had a comprehensive and complete theory of exactly what those things mean. I think the research on what this means is perhaps not as good as it should be, in part because it hasn't really been litigated. But I think a few things can be said. One is faithfully executed does not mean that you must enforce all laws at all times. Otherwise, all presidents would always have been in violation of it. It also, I think, does not mean that you can't rely on policy or moral considerations to make distinctions. Otherwise, again, all presidents throughout our history would have been in violation, so it can't mean that. You might say, well, what does it mean? We don't want to read this out of the Constitution entirely. I would suggest it means a couple things. One is it says that you can't do a suspension of the laws. You can't say that what these people are doing is actually legal in the first place, and therefore they're immunized against any future action. That indeed was a concern of the Founding Fathers. The kings of England had done things like this, but this order doesn't do it. It doesn't say that what they're doing is legal. Indeed, a new president at any, or even this one at any time, can reverse the order and start actions against these people. That's very different from what he did with, say, some of the Obamacare mandates, where he said not only are we not going to enforce this, but we're going to say that these people who don't follow the mandates, they're actually acting legally. Now, there is in this order just the term lawful presence, which sounds like a very ominous and important term until you recognize that under the current law, there actually is no law as such against the presence of these people in the U.S. There's simply a law against them entering, which is a civil offense. So these words, lawful presence, all they mean is that for so long as the order is in place, they're not going to be forced out and deported. It doesn't mean that their initial entry is itself considered lawful. It doesn't mean that they get immunity from any kind of future action. They don't. So ultimately, I think this case is important. It raises some difficult issues. And I admit that it's troubling when the president has discretion this broad. But the root of the problem is that we have so much federal law that it's almost inevitable that he has broad discretion. If we want to fix that, the way to do that is to cut back on the scope of federal power, to limit the scope of federal laws such that the president really could enforce them all, and such that they're limited to those where we have a broad consensus that this really should be something that the federal government should be doing. Thank you very much.
Line up here, so please line up. Let's go rapid fire.
question is for Professor Solomon. I'm John Duggar, University of Nebraska. I have a question about security. You advocate this ultra-open border ideal and how wonderful it is. I can only assume and share this with the entire world. What do you think would happen to Israel if you implemented this idea? What do you think would happen to Israel if you implemented this ideal? Do you think they would last a month? And if not, what makes you think that would work in America?
So I would say two things. One is, for pretty obvious reasons, Israel's strategic situation is extremely different from ours, namely that Israel is surrounded by nations that and polities that it is at war with and that sponsor terrorism. No, we're not. We're not at war with Mexico or Canada or any of the other nations from which we have.
Have you forgotten 9/11?
Okay, so do you want me to answer a question or do you want to ask additional questions? If you want to ask some additional questions, please go ahead. Otherwise, I'll answer the question that you initially posed. And my answer is this. Yes, of course, we can restrict things based on security when we actually have evidence that particular people are terrorists, foreign spies, invading armies and so forth. What we cannot and should not do is restrict people simply based on where they happen to be born. And indeed, if you look throughout our history in the last several decades, yes, it's true there's some risk of foreign terrorism. We have had many more people killed in this country because of domestic terrorism, indeed since 9/11, even on a per capita basis. And if you look domestically, there are some people who demographically are far more likely to be domestic terrorists than others. For instance, young white males, it turns out, are more likely to be. It doesn't follow that we can impose massive restrictions on the freedom of all the people who happen to share that demographic background. And the same point applies in the immigration context. Maybe a different situation with countries where we actually are at war. That might fall under various powers of national defense. But with respect to immigration, pretty much all the countries that we're talking about are not countries that we're at war with. Whereas with Israel, they are in fact in a state of war with several of their neighbors. So it may be that a situation like Israel's is so extreme that you can do things that would otherwise not be justified. I'm not a believer that anything is an absolute right. I don't believe property is an absolute right, free speech is an absolute right, and so forth. There can be extreme circumstances where the only way to deal with a horrible problem is to violate important rights, but there should be a high burden of proof for doing that, and it should not be used as something that's a general rule.
So I think Elia concedes my point that this is a policy judgment, and the question is who decides it. And he's conceded that some policies require a restriction, and that he disagrees with the congressional determination that other policies don't require restriction. There's a wonderful line in the Chinese exclusion case. It matters not in what form such aggression from foreign nations and encroachment come, whether from the foreign nation acting in its national character or from vast hordes of its people crowding in upon us, right? And if Congress has the ability to make those policy determinations, then it's up to Congress to decide where that balance is, and that's what I've proposed, that this is a political judgment that deserves to be addressed to Congress, not for the courts to strike down the place where they drew the line.
So I would say two things. One is, yes, there is a part of this debate which is about policy and morality and not just legality. With respect to Congress's power, the fact that Congress can exclude some people as threats to national security does not mean that it has a general power to exclude all immigrants anytime it wants. And I think in that passage, in the Chinese exclusion case, what you see is the racism of the time, which severely influenced both the Chinese exclusion case and also the act that it upheld, namely that they conflate invading armies with vast hordes. What are these vast hordes doing? They're coming in, getting jobs, becoming the minority group that today many people actually see as a model minority contributing to America. So I think it is a great danger and very wrong to conflate peaceful migration with invasion. We can stop invasion, but peaceful migration is a different matter.
Thank you. Hi, I'm Andrew Everett from Graduate School here at UVA. And my question, and this is to both the professors, regards the nature, like why some things you don't think were defined, such as why there wasn't specifically a right to travel that was enumerated, or with respect to natural-born citizen, and obviously where that's now becoming controversial to some, that instead of just saying natural-born citizen, it wasn't just defined as somebody born of a U.S. citizen or within the confines of the United States.
I mean, there were some things that were well understood, and I think the negative implication of Article 1, Section 9 demonstrates that the notion that a sovereign gets to control its borders was so well understood that it didn't require elaboration. In fact, one of them says at one point, it says, if we were to put that into the Constitution, we would be the laughingstocks when we get home. The notion that the government needed that enumerated power when that's inherent in every government we would be laughed at if we put that in. And I think something like this, the notion that the sovereign gets to control its borders, if we had to specify that in the Constitution, we would be laughed at. Why are you listing things that everybody knows already exist? Right? And the negative implication of Article 1, Section 9, I think, conveys that idea directly. I mean, even if it's true that it was not part of the naturalization clause, the notion that we couldn't control immigration or direct immigration into this country and give away a power that every other sovereign throughout human history had exercised of right would have been bizarre.
So I think I covered the migration or importation clause before. This is an exception to congressional power, but it's not an exception to any kind of generalized power to control migration. It's an exception to the power to regulate importation of slaves and indentured servants and the like. That's what people like James Madison and others said at the time, and I think that's the reasonable way to read it. Now, John says we would be a laughingstock if we specified this. Well, maybe we're a laughingstock, but they did specify the power to declare war, to raise armies, to provide for defense. If there's anything that's an inherent power of any sovereign, it's surely that. Yet we did specify that. Why did we do that? Because the American Constitution has a principle that in fact did not exist in most, or perhaps maybe in any previous constitutions, which is that the government's powers are limited, at least the federal government's. They're supposed to be enumerated, and so the government has those powers that are specifically listed and enumerated, but not other powers. I would note also with respect to migration and the like, the situation in the 18th and 19th century was quite different than it is today. Yes, some sovereigns had migration restrictions, but in many of the nations of Western Europe, there was actually pretty free and open movement, particularly in peacetime, but even sometimes even in wartime. So the kind of massive, large-scale migration restrictions that we now have today did not become commonplace until the 19th and early 20th centuries. It is true, it was thought that kings and others had inherent authority to do what they wanted, but this was the sort of notion that the American Revolution was fought to overthrow. Sorry, go ahead.
Yeah, look. The power to declare war is given there because it was the king that had the power to declare war before as the sovereign. And the reason it's in the Constitution is not because they didn't recognize that the national government wouldn't have the power to declare war. It's put there in Article 1 to make sure it was Congress that had that power and not the executive unilaterally. If they had not had it there, the federal government would have clearly had the power to declare war, but we would have had a fight over which branch had it. So the fact that it's there doesn't mean it wouldn't have existed had it not been there.
We could say the same thing about whether the executive or Congress had the power to regulate this area.
Yeah.
Ilya Shapiro from the Cato Institute. Assuming John is right that sovereigns can control their borders, and I don't see how you can have a country in the Westphalian system without that, but assuming that Ilya is right that the immigration laws are written so broadly that the president can essentially do whatever he wants, wouldn't that mean that that legislation itself, if any example, is a violation of the anti-delegation principle? That is, if Congress has this power of controlling the borders, let's assume arguendo that it does, but it's written such a broad law to delegate almost essentially the entire power to the president, wouldn't that have to be a violation of anti-delegation? Yeah.
I think that's a good question, and I was remiss in not addressing the delegation issue in my previous presentation. In one sense, I actually agree. That would be, at least from an originalist point of view, that would be perhaps an overbroad delegation in some ways, but the non-delegation doctrine under modern precedent is pretty much dead. You can see lots of cases. I think it should not be dead. We should go back to the original meaning, but obviously, if we're going to reverse many decades of precedent in this area, then I would say look at the immigration power again as well. I will also say that a very broad delegation is probably inevitable given the enormous scope of federal powers that exist today. So I don't think we can restore the original meaning of delegation or anything like it unless we also restore the original scope of federal power as well. And neither one of those things are going to be done anytime soon. And I don't think either one of them can be done by the Supreme Court alone for a variety of reasons, both political and precedential. potential and the like, but I don't think you can say, well, we're going to restore non-delegation, and we can do that even though we weave in place all of the things that make a meaningful non-delegation doctrine in the modern context impossible.
Yeah, so if there ever was a non-delegation case that even under the existing moribund state would rise, the fact that, or to the Attorney General, which, by the way, makes the last 15 years of fights over the DREAM Act in Congress completely irrelevant, because the President apparently had the authority all along, right? Nobody thought that. That's why we fought this. Or by the Attorney General doesn't even have any pretense of language constraining the discretion of the executive. But I want to challenge the premise as well, because these statutes are not a broad delegation. Even on the discretion, I mean, how would Congress curtail discretion on prosecution? On the drug laws, for example, it would not just make the prohibition, but it would say the Attorney General shall enforce every instance of the violation. And that would clearly, as a matter of text, remove any discretion the prosecution had. Well, it turns out these immigration statutes do that. If you don't meet the criteria for continued presence in the United States, the immigration laws say that that the immigration officials shall initiate deportation proceedings against you. And the only court that has addressed this issue before it realized it didn't have subject matter jurisdiction and shifted it over to the Merit Systems Protection Board, was the Northern District of Texas, and it said the word shall removed any discretion that might otherwise have existed. And I think that's true. And so if we assume that Congress has power to protect the borders, the word shall removes the discretion that the executive had, and we don't even get into the non-delegation issue.
Two very small points. Again, it's very important to distinguish between protecting the borders in the sense of preventing violence and the like, and preventing peaceful migration. These are not the same thing, and they're relevantly different, both morally and legally. With respect also to this question of shall, if you follow this logical conclusion, that would mean that the president has a duty to initiate deportation against every single immigrant, or every single illegal one at least, completely eliminating any kind of discretion. That would mean that the last many decades of immigration policy and practice are illegal, and I think it's not plausible to read the statutes in that sort of a way. And I would also say, even if there is this word shall, the point about authorized by the Attorney General, that's actually an exception to the general ban on employment, so it's an exception to the more general phrases about shall as well. It's a pretty standard principle of statutory interpretation is that more specific language governs more general language when the two might conflict.
But that cuts my way. Or by the Attorney General is a very generic throwaway in a definitional statute. These other ones specifically define what the obligations of the Attorney General and Immigration Services are. You shall put, if you come across somebody who is unlawfully present in the United States, you shall initiate deportation proceedings against them. So the fact that you don't go out of your way to find people, once you've come across them, you shall do it. Takes away the discretion not to follow through on that.
Thank you. My name is Jason Morgan. I'm at the University of Wisconsin. Thank you for a great debate. I have a question about clarifying the terms. This is an immigration debate, but I'm beginning to wonder if we're really talking about immigration at all. There was a discussion about Jefferson and free migration. And I was thinking that the reason that we're at this wonderful university is because Jefferson loved this particular place and not other places, but this area of Virginia. And I wonder if immigration debate that we're having now is not, at least in part, a function of our different view of place in the United States, and whether even disregarding people coming in from other places, whether we as Americans love our own places, our own hometowns as much as we used to. And I wonder if this debate looks different when we stop talking about America as being a nation of immigrants and as being a nation of settlers. And it seems that we are here because people settled this land and didn't just sort of pass through. I wonder if we're talking about two different things, sort of Jeffersonian immigration and 2016 by immigration.
So I think this may raise much broader issues about people's sense of place and localism and what people are like. I think it varies. Some people, quite understandably, are very attached to a very specific place. They love it. They live there their whole lives and so forth. Other people are more mobile. Over 40% of Americans have made at least one interstate move in their lifetime. I think a just and free society would take account of the diversity of people in that respect. John mentioned property and letting people in your house. I think that's actually an important principle. People should be allowed to decide who comes into their house, but the government does not own all of our own houses. It shouldn't make that decision for each and every one of us. So if John doesn't want to let certain people in his house, I totally respect that. But by the same token, he and the government should respect my right to choose differently with respect to my house. I think in a free society, we don't have to have a single centralized decision on how localist we are or on what kind of people should be able to go into which houses or work in particular businesses. I think individuals, by and large, should be able to decide that for themselves. That is one of the fundamental principles of natural rights that I think Jefferson talked about in his career in the Declaration of Independence and elsewhere.
Yeah, I have a distinctly different view, as should be evident by now if it wasn't before. Look, the habituation into norms of Republican institutions was foremost in their mind. The notion that Jefferson would have allowed mass migration from people who were not habituated and therefore immediately capable of fostering those Republican institutions is just false. They were careful about this, and they designed the institution to encourage the migration of people who would foster that, who would take up the self-reliance, the yeoman farmer aspect of Jefferson's thing, but not people that would destroy that, because it would have destroyed their experiment in self-government. And the people that get to decide those questions are those who already form the body politic, that one people that I mentioned in the Declaration. Jefferson didn't use that language accidentally. Right? And if you recognize that and that forms the basis of the consent of particular rather than universal regimes, then you've got to be able to make these distinctions someplace. And so the big fight we ought to be having is where did they assign that power, not whether it exists someplace at all.
One more small point about, because I think John raised an important issue about self-government, and I think this perhaps is the single best argument for immigration restrictions. What if you bring in people who destroy the good institutions we have, and that they could create a danger? I would say two things about that. One about Jefferson and the founding, the other about history more generally. With respect to Jefferson and the founding, it's simply not true that Jefferson and others of his ideological persuasion wanted to exclude such people. Jefferson was among those who argued that the Alien Act was unconstitutional because it didn't give Congress the power, the Constitution didn't give Congress the power to impose general immigration restrictions. His Secretary of the Treasury, Albert Gallatin, who was a leading constitutional theorist in the Jefferson administration, made this argument repeatedly. With respect to the migration of people from non-Republican regimes, Jefferson was actually very much in favor of that. Where were immigrants coming from in the 1790s? Places like France and Germany, who were ruled by authoritarian, oppressive monarchies. And so, yes, it was important to habituate them to liberty and Republican government, but the way to do that was not through immigration restrictions. The last thing I would say is that since Jefferson, of course, we have a lot of social science on this. I'm not going to try to summarize all of it, but I would say two things. One is that when we look historically, first of all, recent immigrants don't have that much political power. Many of them can't vote. Even when they do vote, they vote at much lower rates. They have less political influence. So the notion that they could immediately make a big change is relatively small. Second, we actually have a lot of public opinion data, and what it shows is that by the second, third, and fourth generation, there's actually on most issues not that much difference between the political views of immigrants and those of natives. So, and if there was a big difference, the way to handle that would be things like restrictions on citizenship. And I would note, by the way, that we already have rules under which immigrants cannot become citizens unless they pass tests of civic knowledge that, frankly, most native-born Americans would fail. Granted, maybe that test is not the right way. Maybe it should be made different and tougher. We can talk about that. But as I said earlier, the issue of admission to citizenship and the issue of voting eligibility and the like, these are different things from the right to free migration. The founders understood the separation between them, and we should too.
I want to say to those of you that still have questions, please come up afterwards and ask them. I'm sorry, but we have to stop. I want to first say what a great debate. You have to come to the Federalist Society Symposium to get this debate, and the reason is we don't have diversity of viewpoint in our law schools. You can do something about that. At 12:15 today, for those of you that are interested, there's a great lunch talk about becoming a law professor. And if more of you decide to become law professors, we won't have to come to symposiums and spend money when we already pay $70,000 to go to law school. So I would encourage those of you that are interested to please go to that session. It may be one of the most important ones here. And thank you very much to the two professors for a great debate.